Do we have any counsel that's in the jail court that's ready to proceed?
Can't unmute. I'm sorry, Your Honor, I can't unmute today.
It's okay, no problem.
We do have a couple of attorneys ready. I thought we were going to get Mr. Wood taken care of first.
Mr. Wood, okay, yeah. I've got Mr. Wood online. So do we have Mr. Turnage? Mr. Turnage, if you'll come on up. Let me bring Mr. Wood in. Good afternoon, Mr. Wood.
Good afternoon, Judge. You have a nice background there, sir.
Thank you very much. This is the pre-flood Van Zandt County Courthouse.
Yeah.
What you're seeing now virtually is the pre-flood. And
I couldn't tell at all.
well, that's the problem, is because it hadn't changed since 1937. But that's needed. Well, that is very much here and here. So, all right, this is cause number CR 2198 and CR 2199. We're having a status today on Mr. Turnage. Any updates for the court, Mr. Wood?
Judge, I've truthfully not had an opportunity since Mr. Turnage has began taking his medication, which my understanding is he is taken. I've not had an opportunity to go see him and sit down with him in person just to I guess, personally evaluate kind of where I stand on the matter at this point. I am going to be up there tomorrow. And so I can possibly try to go by there to see him then, and may have a better announcement as far as how this process is going.
I do have a notation on my docket that Ms. Tabraham indicated that Mr. Turnage is, as of July 15th, roughly a month ago or so, he was number 121 on the list for the maximum security unit. So let's set Mr. Turnage. I'll give you some time, Mr. Wood, so that you can meet with Brett, see how he's doing, and we'll do it shorter rather than later if your schedule allows. Probably the earliest I could get you though would be September 22nd.
That's fine, Judge. I mean, and especially if we can do it on Zoom, kind of like this, and truthfully, I can probably let the court know, and as well, with the prosecutor being present, kind of what my opinions of the matter are before that point.
Okay. Mr. Turnage, how are you doing today, sir?
I'm good, same as usual.
Same as usual. Good. Do you have anything to report to the court, or you want me or Mr. Wood to know?
I would like Mr. Wood to know that the situation isn't going to change. This medicine thing isn't going to fix what I've dealt with and what I've been dealing with. Is the reason why my grandma is forcing me through this. She has done this pretty much my whole life. And in this, the situation that I have been dealing with out of these neighbors has gotten to the point where it's pushed her to this, because they have done such serious things. I have buried my dogs. I've had to bury 2 of my dogs. I've been trying to explain this to you for 2 years now. They've done serious stuff, and my grandma does not understand is why I'm being forced through this.
Okay, I understand. All right. Well, Mr. Wood said he's going to try to stop by and see you hopefully this week or so, and you can talk to him more about that. And we're going to come back on September 22nd, and we'll have another announcement on your case. Okay, Brett?
All right.
Is that all you have, Mr. Wood?
That's all I have for this afternoon, Judge. So
Then you're excused. Good to see you.
good to see you too, bud.
All right. Mr. Weiner, how are you today, sir?
I'm fine, sir. How are you?
Well, I've been better, but I'm still not in a position where I can complain too much, you know?
Good. It wouldn't help anyway.
Wouldn't help anyway. All right, this is cause number CR 372, Mr. Williams, Leonard Williams. You'll come up, Mr. Williams. Mr. Williams is set for docket call today.
He is, Judge. This is my second appearance on the case. I subbed in for a previous court-appointed lawyer. Since the last setting, I've received the discovery, reviewed the discovery. I've spoken with the state. We've made some significant progress in negotiation. I've spoken with my client about the discovery. There is some additional information outside of the discovery he's provided me that I need to discuss with the state. I understand the court isn't wanting this to just tarry on the, docket call forever. And so I would just either ask for a short reset, or if we can set it for a contested docket, which would give me time to talk to the state and see if we actually need to have a contested hearing, whatever the court wants, but we're working through this as fast as we can and making progress.
And remind me, is this a revocation? It's not indicated on my docket.
No,
Is this-
Your Honor.
No. And
It's a
so,
first-degree felony.
and so the contested nature that you're talking about, are you indicating that we set it for trial, or you tell me more about that?
Either set it for a contested docket, just so that way I can talk to the state. If we have to have a contested hearing, we're not back for another docket call and then having to put it for a contested docket. But I believe at the next setting, if you put it at a contested docket, we'll either have a contested hearing or say, Judge, we don't need it. We just need to go on the trial docket. Does that make more sense?
And so you said this is not a probation case, right?
No, Your Honor. It's
Okay.
first.
But we're not on a contested docket for a motion to suppress or a contest. Are there contested motions?
I have not filed one yet. Like I said, I just spoke with my client. There's some additional information that I just got that's outside the discovery I was provided that I have not had a chance to talk to the state about.
Okay. So I think the best, so I would want to set it for a contested docket, because I actually want cases set on those days that actually have something to be adjudicated, either, suppression, quash, something of that nature. What I can do for you, if there's no objection from the state, is give you one final docket call, and Mr. Williams can make his decision as to whether he wants a trial or a plea agreement. The earliest I could bring you back would be it'd probably be September 22nd or 27th. That's another 30 days for Mr. Williams.
I believe the 27th would be fine at 1:30.
State, do you have any objection or position?
Judge, seeing as how this is Mr. Weiner's only second setting, I'm aware he is the second attorney. We did have a fairly meaningful discussion the other day. State would be unopposed to one more docket call, see if we can't work out whatever it is that Mr. Williams wants to bring to our attention, see if we can't reach some resolution.
Okay. Court will set Mr. Williams for a final docket call on September 27th. That'll be at 1:30.
Thank you, Judge. He's signing the reset now. After that, may I be excused?
You may. Thank you, Mr. Weiner.
Thank you.
Into the state that nobody's going to do it, and I want to listen to I wrote.
Mr. Manning, just be aware that the microphone is on, so don't let him say anything you don't want us to hear.
Thank you.
All right, Mr. Manning, who do you have with you?
Judge, we have Mr. Boylan. We were set today for a plea. We're going to ask to reset that per agreement by the state. We set that for a status on a couple things we're going to check into.
All right. Court, any objection from the state? I understand there is none.
No, Your Honor.
Okay. Court will reset Mr. Boylan then for status of competency evaluation or reevaluation. Court will set that. Let's set it in October, Mr. Manning,
Yes, Judge.
so we have time. Is October 11th acceptable? Or actually, for you, maybe October 13th, that'd be a Thursday. All right, court sets Mr. Boylan for status on competency reevaluation, October 13th in all cases.
It's what I wanted to read to put one into his head.
Who do you want next, Mr. Manning?
Judge, I think the only one I have left is Mr. Hagan.
Jeffrey Ray Hagan, CR 22, 180 and 181.
Judge, we do not have any contested pretrial matters at this time. We'd ask that we reserve the ability to file any contested pretrials that become available between now and our setting on the jury trial docket. We're ready to proceed to the docket call announcement for whatever date the court has available.
All right, this is also cause number CR 22, 182. All right, court will find that Mr. Hagan does not have any contested pretrial motions at this time. We will set this matter for for docket call hearing on September 22nd. You're fine with that, Mr. Manning?
Yes, Judge.
All right, and that will be at 1:30 as long as Mr. Hagan is in custody.
Judge, I believe that concludes my matters. May be excused.
Yes, thank you, Mr. Manning.
Thank you, Judge. September.
Mr. Adams, are you ready?
Ready, Your Honor.
Who are you ready on?
Mr. McCaslin, Roger McCaslin.
All right, CR 21, 362, Roger DeLoss McCaslin set for plea today. All right, and I don't have the plea papers before me, so I'm gonna need one of you honorable counsel to tell me what the terms of the plea are.
I'll go ahead and do that, Your Honor. Mr. McCaslin is going to be pleading to a lesser included offense, that being tampering or fabricating with physical evidence intent to impair human corpse. In exchange for his plea of guilty, the state is going to recommend a prison confinement of 12 years in the Texas Department of Criminal Justice Institutional Division, along with a $500 fine. The state will also recommend, and I'm going to miss the details on the next part of it, and I would defer to Mr. Woodwalk about this, but the state is going to 1245 dismiss two other charges. And without the judgment in front of me, I would probably misspeak. So Mr. Woodwalk can clarify that part of it. I would be fine with that.
So the judgment's not there in the jail with you. We need to get Mr. McCaslin's fingerprint on that.
Here
So it should be there.
is just been returned to me. The two cases to be considered are DA number 2021-1200, engaging in organized criminal activity, and DA 2021-1201, tampering, fabricating physical evidence with intent to impair.
All right, and what kind of credit time does Mr. McCaslin have?
383 days.
383?
Yes.
And is there any, court costs would be 290, I presume?
Court costs are $290. There's a $20 reimbursement fee. And then the aforementioned $500 fine.
All right, and so the tampering with physical evidence, human corpse, is that a second degree felony, or is it enhanced to get it above the 10 years?
No, Your Honor, as defined by the statute 3709 of the penal code, that defines it as a second degree felony without enhancements.
Okay, thank you. All right, Mr. McCaslin, if you will, raise your right hand, sir. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may lower your hand. Make sure you speak up loudly and clearly for me so that I can hear you and so that my court reporter can take down everything you have to say. Do you understand?
Yes.
All right, thank you, sir. Your name is Roger DeLoss McCaslin, is that correct?
Yes.
And Mr. McCaslin, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Mitch Adams. Are you pleased with his representation of you? Do
Yes, sir.
you feel like you've had enough time to discuss your case with Mr. Adams and have all of your legal questions answered?
Yes, sir.
And Mr. McCaslin, is there anything about the plea paperwork that you've reviewed and that you've signed today that you do not understand?
No, sir.
And where you signed in the paperwork, you're telling this court that your signature is your true and correct signature, and you only signed that once you were confident you knew what you were signing.
Yes, sir.
Mr. Adams, do you believe your client to be competent today?
Yes, Your Honor. Mr. McCaslin and I have met and conferred on several occasions about this matter. And none of those occasions has there been any question other than that Mr. McCaslin is legally, mentally competent.
And Mr. Adams, you've explained to Mr. McCaslin his rights as they pertain to this case, and you believe he understands those and the waivers of any of those that he's making today?
That is correct, Your Honor.
Okay. All right. Mr. McCaslin, how do you plead to the lesser offense, second degree felony of tampering with physical evidence, human corpse?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty to this crime?
No, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Adams, any objection to the state's evidence, which is the stipulation marked as State's Exhibit 1?
No objection is marked and offered.
All right, State's Exhibit 1 is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor. Basically, because you don't have the stipulation to support the plea, we believed at the beginning that Mr. McCaslin was involved with the murder that we're at this point alleging that Mr. Casey Spriggs committed. Based on our further investigation, we are of the opinion that Mr. McCaslin was not present or we can at least not prove that he was present at the time of the murder. What we can prove, however, is that on the date in question, Mr. McCaslin traveled with Mr. Spriggs to Van Zandt County with the body of the decedent, buried him in a grave out here. Mr. McCaslin has some evidence that he was threatened in some form or fashion. We don't believe that that is justification for this, but it does weigh in some regard to our decision making. Buried the decedent, Mr. My computer just crashed. Judge, are you here?
Yes.
Okay, it's freezing up on me. You're frozen, but my computer is not cooperating. So I'm gonna assume you can still hear me. So he helped, basically he is a party to the burial of the decedent here in Van Zandt County. I think that's basically everything that we've got.
Okay.
The murder allegedly occurred in Dallas. The decedent was brought here by Mr. Spriggs and Mr. McCaslin to destroy the evidence.
All right, thank you, Mr. Woodward. And Mr. Adams, do you have any objection to that summary, or would you like to make any additions or deletions?
I don't necessarily have any objection to it, Your Honor. Our theory of the case would be if we were to go to trial on a murder charge, that Mr. McCaslin, my client, was not present when Mr. Spriggs murdered the decedent. He was not present. That he found out about it after Mr. Spriggs informed him of what he had done. And then Mr. McCaslin, out of an error of judgment, agreed to accompany Mr. Spriggs from Dallas to Van Zandt County in order to dispose of the decedent's remains. And so I think we are pretty much congruent with the state and its theory of the case as well.
Thank you, Mr. Adams. All right, then, based on the evidence before the court and the recommendation made by the state of Texas, the court will accept the defendant's plea of guilt. Court will follow the plea agreement in this case. Court hereby finds that there is sufficient evidence to convict Roger McCaslin of tampering with physical evidence to impair its availability, to wit, a human corpse, a second-degree felony. In accordance with the plea agreement, the court assesses punishment at 12 years confinement in the Texas Department of Criminal Justice Institutional Division, orders Mr. McCaslin to pay a $500 fine, $290 court cost, $20 reimbursement fees. The court dismisses and takes into consideration under section 1245 DA 2021-1200 and DA 2021-1201. Court hereby awards Mr. McCaslin 383 days credit towards his sentence for the time that he has spent in jail prior to this plea on this cause. Mr. McCaslin, you are hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over with the deputy to be fingerprinted.
Thank you.
You're welcome.
Your Honor, that's all I have on the court's docket this afternoon. My excuse.
Yes, thank you, Mr. Adams. I appreciate you.
Thank you, Your Honor. Good to see you.
Mr. Woodwike, has your computer gotten any better?
Yes, Judge, it appears to be, there's a problem with our case management software. It was eating up too much memory and blocked up my whole thing, but I closed that window and now I seem to be back. Van Zandt County Equipment.
Good. All right.
Very good.
All right, Deputy McLeish, do we have any other attorneys or individuals without attorneys that are ready?
We have Miss Shania Doby is here for Mr. Linder. Is he present on Zoom?
He is present on Zoom, yes. Mr. Linder, if you can turn on your device at this time, we're ready to call your client, Miss Doby.
Hey there, Judge. It's his legal assistant, Alexis. He's actually finishing up a federal Zoom. He said 5 minutes, if there's any way possible, you could give him that.
Okay, yeah, I'll recall the case in a little bit.
Okay, thank you. I appreciate it.
Yes, ma'am, I'm going to put him back in the waiting room and then I'll pull him back in at the right time, okay?
Thank you.
You're welcome. All right, we'll try again. Where are we ready on now, Deputy?
Nobody, Your Honor. I just got a response from Mr. Abraham about the others. I guess we don't have Mr. Ashmore there at the courthouse either, correct?
Mr. Ashmore?
Yes, sir.
Not to my knowledge.
Okay, then we are waiting on Mr. Ashmore and Mr. Knoll.
Yeah, I don't see Mr. Knoll on Zoom. Let's
Okay.
see. And then, so we can do this, for the record, cause number CR 21-317 State versus Joseph Dan Aguado. We had Mr. Aguado set for, status of his competency restoration in the waiting list. In July, he was number 136 for Terrell State Hospital. It's my understanding that Mr. Stevens cannot be here today due to, I believe, an emergency within the family. And so the court is not going to have Mr. Aguado brought up. And is there any announcement from the state on that, Mr. Woodward?
Judge, Mr. Stevens, and I have been in some discussions regarding this case, but if we could have it set out probably about a month, just like we did Mr. Turnage. Hopefully we can have some movement, whether it's through us or the state hospital. That's about as far as I'm probably able to go at this time.
All right, cool. We'll set Aguado for September 22nd, 1:30 for status. All right, so I see that Mr. White has a client that's going to be appearing at the jail, Mr. Mahoney, that appears to be a plea agreement. We're waiting on, let's see, Mr. Knoll. And Mr. Ashmore, Mr. Linder will recall. For the record, cause number CR 21-370 State versus Justin Lee Smith, set for docket call. Mr. Stephen Green has notified the court that he's ill and unable to be here today. We had that case set for docket call and also motion for bond reduction. I'm going to carry both forward to 9/22. And Mr. Green was unable to appear via Zoom. So if we can just we can just fill out a notice of setting for Mr. Smith, and I'm sure that Mr. Green's probably already contacted him, but just in case, let him know that Mr. Smith, Mr. Green is unavailable and we've reset him to 9/22. Are you Ms. Stifler?
Yes, Your Honor.
All right, you're Julie D. Stifler. This is CR 22-230. Ms. Stifler, you're set for arraignment today on a possession of controlled substance. It is a second-degree felony and it carries a range of punishment if you were convicted and sentenced to a period in prison not less than 2 years or more than 20 years and a fine not to exceed $10,000. I see that you've requested a court-appointed attorney. Based on the paperwork that the court has reviewed, I do not find that you meet the financial qualifications to be deemed indigent. So that means that based on the assets and the money that you have, the court would not appoint you an attorney. What I can do is I can reset your case to give you time to gather your resources, have your family gather resources to hire an attorney. Is that something you think you can do?
Yes, Your Honor.
Okay. And I can reset it about 30 days. Do you think that's something you can get done before then?
Yes, Your Honor.
Okay. All right, Ms. Stifler, I'm going to reset you for arraignment on September 22nd. That will be at 9 a.m.
Thank you. Will I be able to bond out?
Yes, I mean, there's a bond in your case, so yes, you're able to bond out to my knowledge.
Thank you.
You're welcome.
All right. Yeah. Thank you.
All right, so Deputy Police, Mr. White, you ready?
I guess I am. I just came up here and didn't ask if I could do anything. I just decided to do it.
No, it's a good thing because I was about to take a recess because I thought you still needed more time. But if you're ready, I'm ready.
Yes,
All right, Mr. Mahoney, you'll come on up, CR 2296 and 297. Mr. White, I do have the plea in front of me. Let me look here.
I will say this, Your Honor, on the judgment, we're proceeding on the first degree manufacturing delivery. The judgment has that we're pleading true to the enhancements, which would make it a 15 case, but we're pleading to 6 years. So I believe the state's dropping the enhancement on that. I just noticed it.
That is true, Your Honor.
All right, so I'll need the state to send over a revised judgment to the jail so that Mr. Mahoney can be fingerprinted on that one. So you're gonna drop the enhancement paragraph, so you'll remove the finding of true.
Yes, Judge.
All right, and so that will result in first degree. And so the plea agreement is still the same. Plead guilty, recommend 6 years confinement, TDC, $3,000 fine, 1245 CR 2296, along with $180 restitution, plus $35 reimbursement fees, plus $290 court costs, with Mr. Mahoney getting 14 days in jail credit towards his sentence for the time that he's been in jail on this cause prior to the plea. Is that correct, Mr. White?
Yes, sir. That's our understanding of it.
Okay. All right, Mr. Mahoney, if you'll raise your right hand, sir, I'm going to place you under oath. Mr. Mahoney, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right. Make sure you put your hand down. Make sure you speak up loudly and clearly for me so I can hear you. Mr. Mahoney, your name is Simon Lee Mahoney. Is that right?
Yes, sir.
And Mr. Mahoney, are you a United States citizen?
Yes, sir.
And do you read, write, and speak English?
Yes, sir. I do it.
And has anyone, hang on, give me just 1 second here. Oh, technical issue. All right, and Mr. Mahoney, have you ever been diagnosed with any type of mental condition?
No, sir.
Okay, and in this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you?
Yes, I am.
Do you feel like you've had enough time to discuss the case with him and have all of your legal questions answered?
Yes, sir. I do.
And is there anything about this paperwork that you've read and signed today that you do not understand?
No, sir.
All right, and Mr. White, do you believe Mr. Mahoney to be competent today?
Your Honor, I believe Mr. Mahoney is competent, that he understands the proceedings that are pending against him here today in front of the court, or not in front of the court. Out here at the jail, we have executed a number of waivers that contain Mr. Mahoney's constitutional rights. He has waived those rights knowingly, intelligently, and voluntarily.
All right, thank you, Mr. White. All right, Mr. Mahoney, you are charged with a first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams, less than 200 grams. The range of punishment for that crime is confinement of not less than 2 years. I'm sorry, not less than 5 years or more than 99 years, or life confinement in the Texas Department of Criminal Justice. Do you understand that full range of punishment?
Yes, sir.
And you heard what the court discussed with counsel as being the plea agreement in your case. Is that correct?
Yes, sir.
And is that your understanding of the plea agreement and what you want the court to approve today?
Yes, sir.
Okay. All right. So, Mr. Mahoney, at this time, I'm going to ask you, how do you plead to manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams, less than 200 grams?
Guilty, sir.
Are you pleading guilty, Mr. Mahoney, to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Mr. Mahoney, has anyone threatened, forced, or pressured you to plead guilty to this court today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
No objection.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just briefly, Mr. Mahoney did have a co-defendant who is now deceased. He was murdered shortly after this. Just in defense of this plea deal, we do believe that the co-defendant, Mr. Moses, was likely the main actor in this in this case, we do believe that Mr. Mahoney was a party, but we do believe that the co-defendant was the primary actor in here, hence the dropping of the enhancement and moving forward with this plea.
Thank you, Mr. White. Anything further from the defense, Mr. White?
No, sir, we agree with Mr.
All right. Court's going to review the evidence briefly. All right, the court has reviewed the evidence. I do find sufficient evidence to convict Mr. Mahoney. The court will follow the plea agreement between the state and the defendant. Court hereby convicts Simon Lee Mahoney of manufacture, delivery of a controlled substance, first-degree felony. Penalty group 1, greater than or equal to 4 grams, less than 200 grams. Court hereby assesses punishment at 6 years confinement in the Texas Department of Criminal Justice Institutional Division. Orders Mr. Mahoney to pay a fine of $3,000, $290 court cost, $35 reimbursement fee, $180 restitution. Court also dismisses CR 2296 under section 1245 of the Texas Penal Code, and the court awards Mr. Mahoney 14 days credit towards his sentence for the time that he spent in jail on this cause. Mr. Mahoney, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over with Deputy McLeish to be fingerprinted.
And Judge, I will have my office send a corrected judgment to the jail to have his fingerprint and then brought to the court for its signature.
All right, thank you.
Your Honor, that's all I have, man. Excuse.
Yes, thank you, Mr. White. Appreciate you.
Thank you.
Natural.
Yeah.
Okay.
All right, Mr. Knoll, are you ready?
Sure. We're gonna do that.
Well, Mr. Knoll was here and then he wasn't.
You can take him on out, Mr. Heiser, thank you. Right.
Okay.
Have you figured it out yet, Mr. Knoll?
I'm sorry, Judge, I don't know if it's my audio. I think I can hear you okay.
Can you hear me okay?
Yes, I can hear you.
All right, I said, have you got it figured out yet?
Yeah, it wasn't technical error. It was operator error. I don't know. Did something wrong. At any rate.
All right, I believe Deputy McLeish says that both of your clients are present in the courtroom, Michael Marley and Printavious Moorhead. Which one would you like to call first?
I think Mr. Marley, I have no idea if Hillary's had a chance to, and I haven't really communicated to her. I think I did. But
All right, well, let me call the case if we're going to call Marley. CR 21-225, State versus Michael Paul Marley, set for docket call. Sorry to interrupt. Go ahead, Mr. Knoll.
Judge, part of the, I guess, for lack of a better way of phrasing it, behavior on the date in question was, I believe, based on one, alcohol, which was probably too much consumption of, along with some medications that were given to him for a surgery that was done just a few days before, as I recall. And I was hoping that might influence the type of offer that the state would make in the case.
And Judge, let me jump in there and say that the state has reviewed Mr. Marley's medical records. There were a couple hundred pages. So I did review those and I have sent Mr. Knoll an updated offer as of about 30 minutes ago. But I know he has not had an opportunity to convey that to Mr. Marley. So for that reason, state would not be opposed to one more setting on this, just to allow Mr. Knoll to convey the state's best and final offer to Mr. Marley.
That would seem appropriate, Judge.
All right. When do you think you'll be able to visit with Mr. Marley?
Judge, if I'm lucky, I can get out of here. I need to be in Dallas Friday. If I'm lucky enough to get out of here, I may be able to stop and see him Friday. The next week, on the week of the 29th, I start a continuous sexual assault of a child trial that's been reset for the third time in Dallas. So I hope for the third setting it would actually go, but I think I can meet with him Friday.
All right, so if I set you for September 22nd, you can make that happen?
Yes, I'll definitely meet with him well before then.
All right, so I'm going to set this for the final docket call on September 22nd. That means we're either going to have an announcement for a jury trial, bench trial, or a plea agreement on that day. So whatever, if there's a better offer, it needs to be made. If there's a counter offer, it needs to be made, and we need to be settled up on 9/22.
I understand.
All right, we'll see you on 9/22, Mr. Marley.
Thank you, everybody.
You're welcome.
Thank you, Judge.
Printavious Moorhead, CR 21-180.
Judge,
Mr. Moorhead set for pretrial.
yes, I have not well, this is a strange situation. I think if my memory serves me correctly, I'm either the third or the fourth lawyer somehow on this case. I think Mr. Moorhead has probably seen more discovery than I have. I have not had the opportunity to finish that. Last week, I thought I was going to be in a aggravated sexual assault trial. I actually got that resolved without trial. I start a trial tomorrow. I will meet with him this Sunday and try to make sure that I understand everything that he understands in the discovery, because I actually think my recollection last time I talked to him is that he has pretty much seen all of it, but I haven't seen all of it. And we need to probably be in the same place and look at it all at the same time.
Have you reviewed discovery to the point where you can say there's no contested pretrial motions needed?
To be honest with the court, and that's what I try to be, no, I haven't.
All right, court's going to set Mr. Moorhead for an additional pretrial on September 22nd at 1:30.
Judge, just for the record, there is also CR 18-00020, which is not on my docket. I don't know if as a court, if we could set them both together so we could have both of Mr. Moorhead's cases running at the same time, I think that would be in the best interest of judicial economy.
And Judge, the CR 18 case, it has been transferred downstairs to the county court at law. You signed a recusal on that. So I don't know if Mr. Knoll would like to do a motion to transfer this case as well so that they can run together. But just as a reminder, the CR 18 is a recusal by you that's been moved down to Judge Winter's court.
Yeah, Judge, I think the second case that Mr. Woodwick was mentioning is I think that's the failure to appear. Is that right?
This is the failure to appear. The other case is his other case, which is more serious, but.
Right. Judge, I think it's probably appropriate if they both go to, I guess that would be Judge Winters. I think we talked about that last time, at least, that there was a recusal on one of the cases. I assume because of the court's involvement when the court was the DA. It's kind of an old case.
Sure. Well, if you'll make the motion, I'll sign it and we can send it
Okay.
down to Judge Winters and he can accept it or reject it.
Okay.
So I'm going to keep him scheduled until he's off my docket. I'm going to keep him scheduled for September 22nd. If it gets transferred before then we'll cancel that docket setting. If not, then we'll we'll keep on moving forward on the case that I'm not recused on.
Thank you, Your Honor.
Thank you, Judge. Is there one more that I think that I may have that's in
Yes.
court?
Yes, Arthur Ibarra, CR 22-159 and 160. Mr. Ibarra is set for docket call in each case.
Judge, I thought we discussed a plea in this case, but obviously I didn't get there to be able to do papers. I honestly don't recall. And I don't remember if it's Ms. Heisel or Mr. Woodwick that's handling this. Judge, maybe we just need to set it for another. Who was that? I'm sorry. Was that Mr. Woodwick that was?
Yeah, I don't know. I was letting the state review.
Judge, these appear to be my cases. It looks like there was an offer made some time ago, but I don't believe that it's ever been accepted or declined. If we could reset for another docket call, allow Mr. Noel and I to finalize our agreement. I have no doubt we will work this out. I just don't believe that we've reached that point to where it's been accepted or not.
What is the offer from Mr. Ibarra right now to resolve his cases?
There was an offer. He has 2 first-degree felonies. There was an offer of 10 years in prison made. It appears to be a couple months ago. I don't know if Mr. Noel was on it at that point or not.
And Judge, I think that was the offer, but I don't remember if that's been confirmed, so to speak, with Mr. Ibarra, but I'd need to, if we could just set him on September 22nd again, we'll either dispose of it that day or I guess set it for some other action.
Okay, we're gonna set Mr. Ibarra for a final docket call on September 22nd. In each case. All right, I'm gonna try to bring Mr. Linder back in. Is that all of our attorneys, Deputy McLeish?
For Mr. Ashmore, yes, sir, that would be it.
Oh, he still has Shelton and Shackelford. Let me see if Mr. Linder is available.
Yes, sir.
I think that's all I have, Judge. May I be excused now?
Yes, thank you, Mr. Noel.
Thank you, Judge.
Good afternoon, Your Honor.
Good afternoon, Mr. Linder. How are you doing today, sir?
Good.
All right, this is cause numbers CR 22-130, CR 22-131, State versus Shayna Sapien Doby. And I show that we are set for docket call and also motion to set bail, I believe. Let's take up the docket call first. Any announcements, Mr. Linder, on whether or not Ms. Doby is going to be rejecting the state's offer and or requesting a bench trial or a jury trial?
We're rejecting the state's offer at where it is now, but we anticipate being able to work out an offer. We have met with the district attorney. We would like to meet again. I placed a phone call and email to the district attorney earlier today. We do believe we can reach an agreement, just not at the first one we've got here today.
Okay. Well, tell me how far apart you are, because typically this is my trial procedure is we go arraignment, pretrial, docket call, and between pretrial and docket call, I expect all offers and counter offers to be made, and then on docket call to be an announcement of whether we're going to trial or plea agreement. And so today you're telling me that your client would want a trial.
Well, she would want a trial over the offer we have today, but I do believe my my conversations with the district attorney have been very reasonable up to this point. So I do believe that we'd be able to come to some agreement. If you need to set it for trial and let us continue working on that, we're happy to do that.
Well, the problem with that is that I try not to accept plea bargains after docket call because people want to take plea agreements on the Friday before the Monday jury selection. And that causes an undue expense to the citizens. It causes them to be pulled in for a jury panel. It causes us to spend money that's not needed. So I try to set a lick log, if you will, of, okay, look, we're going to get to this point and all negotiations are going to be had. And if not, then we're going to trial. And I try not to accept plea agreements after that. So both sides are held to the same burden, so to
I
speak.
understand. We had, just so the court will be aware, we did have a debrief session with my client, with the DA a few weeks ago. We may need to do a second one. I thought we made some progress, which is why we set a bail reduction hearing for today. If the court could reset it for one more of these pre-trials, I believe we'd probably be able to get to some kind of agreement. I mean, it's nothing we want to have to try if we don't have to. I don't want to waste the court's time with an unnecessary trial, but I do understand the court's position of not getting up onto the eve of trial and paying jurors to come in there and then not using them. I get that.
Right. State.
Judge, Mr. Linder has been very communicative with the state. I have not received his email regarding his counter offer, but I'm sure it may be in my junk mailbox. I did receive a voicemail from him this morning. So I'm confident that as long as we are still talking, that progress could still be made here. I don't think, at least at this point, the state is not ready to set for trial saying this is as good as it's ever going to get. So with that being said, I wouldn't be opposed, given the seriousness of this charge, to another setting.
Thank you.
All right. And then are we going to hear the motion to set bail today, or do you want to carry that over to the next setting?
I could be heard just briefly, Your Honor. My client has debriefed. She is, and we anticipate the government would want her cooperation in the future, and we would be willing to do that and put whatever measures in place that we would need to do to assure that. And if she's able to make a reduced bond, we're okay with the house arrest, leg monitor type situation with a family member and have her to continue cooperation. She does not have the ability. I think she has 3 bonds or $250 each. One of the cases hasn't been indicted yet. So I think there's only 2 that have. So she's got a $500,000 bond. But I do believe if the court could lower the cumulative bonds, whatever they be, whether it be 2 bonds or 3, down to something that's like a couple $100,000, $300,000, where her family could come up with $20,000 or $30,000 with a leg monitor and other conditions, I do believe that would suffice. And we could put whatever protections in place, either the court and or the DA would want, to assure her reappearance or non-flight risk, and those assorted factors.
Is the state in agreement with the motion to reduce or set bond?
Your Honor, the state has communicated with Mr. Linder's office that the state would be willing to sign off on a PR bond on the aggravated assault charge, which is not indicted. That would reduce her cumulative bond by $250,000. But the state is not in agreement to a reduction on either of the indicted charges, which I believe both have a $250,000 bond apiece.
Okay. And Mr. Linder, do you want to call your client?
Yes, ma'am, or yes, sir.
All right, Ms. Dobie, if you'll raise your right hand, I'm going to place you under oath. Ms. Dobie, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, I saw your list move, but I didn't hear you. That could be a technological problem, or it could just be that you're not very loud.
Yes, I did.
Okay, thank you. So make sure you speak up loudly and clearly, and if you need to, Deputy McLeish, if she needs to move closer so I can pick her up, we may need to do that. All right, go ahead, Mr. Linder.
Ms. Doby, can you please state your full name for the record?
Dana Sapien Dobie.
And Ms. Doby, you are the defendant in these three cases that are before the court today. And you're going to need to speak up. I can barely hear you.
Sorry. Yes, sir.
Okay. And do you, before being incarcerated, did you live there locally?
Yes, I did.
And where is your extended family?
In Terrell.
Okay. So do you have a passport?
No, I do not.
Do you have any foreign bank accounts or money to get to another country if you were to leave?
No.
If the court were to reduce your bond to a level where your family could probably have to come up with $20,000 or $30,000, do you think you could possibly do that?
It's a little high. I mean,
Okay.
I
You don't have any money right now, do you?
no, I do not.
You have, your father passed away and he's got an estate lawyer working on kind of selling his house and doing some things like that, correct?
Yes.
And you have two children,
Yes, sir.
and where are the children today?
They're with their dad.
And where is he?
He's in Rockwall.
Okay, so everybody you know is within 30 minutes of Van Zandt, correct?
Right.
Do you have any criminal history?
No.
Okay. Have you cooperated with the district attorney's office in giving them information?
Yes, sir, I have.
Would you continue to do so if asked?
Yes, yes.
If they needed you to testify in the trial of your ex-boyfriend, would you cooperate in those efforts?
Yes.
Okay. Do you have, if the judge were to release you on house arrest, do you have a place to go to?
Yes, sir, I do.
And where would that be?
With my husband.
With who?
My husband or
The father of your children?
yes,
Okay. In Rockwall there?
yes.
And does he have a criminal history?
No, sir.
Okay. And are there any weapons in the home?
No, sir.
Okay. Any drug use in the home?
No, sir.
Okay. And CPS has placed the kids there, correct?
Yes, sir.
So they've done a home investigation to the best of your knowledge?
Yes.
And you would be able to live there with an electronic leg monitor if the court so choose to let you out?
Yes, sir.
Okay. I'll pass the witness, Your Honor.
Ms. Heisel.
Thank you, Your Honor. Ms. Doby, true or false, one of your children was involved in the incident for which these indictments arise.
Correct.
Are you aware of any CPS orders that exist right now disallowing you to have contact with your children?
Not that I'm aware of, no.
If there were CPS orders that said you couldn't return to your husband's house with your children, where would you reside?
To my father's house.
And where's that at?
Harold.
In Terrell, okay. Ms. Doby, do you understand that a leg monitor is approximately $300 a month?
Yes.
Okay. Do you believe that you would have the financial resources to comply with that condition if the judge ordered it as a condition of your release?
Yes, ma'am.
Your Honor, I'm going to pass the witness.
Mr. Linder, anything further?
No further question, Your Honor.
All right. Any further evidence, Mr. Linder?
No, sir.
All right. Ms. Heisel, any evidence or argument?
No evidence from the state, Your Honor, but I would just make a brief argument.
All right. Mr. Linder, do you want to argue your motion?
Yes, sir. My client, as mentioned, has no criminal history. She has children in the neighborhood, or children locally there with her husband that CPS has placed there. She has no passport, ability to flee. She doesn't have a car. She doesn't have any property. She could live at either, if CPS wouldn't allow her to live with her kids, she could live at her father's house. Her father just recently passed away. And they have a probate lawyer that's managing that house and things like that. She doesn't have an excess of money in which to post a huge bond, but through her father's small estate, she could probably come up with the 20 grand or so to get out and pay the leg monitor. I will.
Mr. Linder, let me ask you, how do I know any of that? Because she didn't testify to what financial ability she has. She didn't testify to assets. She didn't testify whether she was working, whether she had cash in account, whether she had a car. She didn't testify to any of that. So I'm not sure that I can consider any of those things.
Would you let me recall her?
Yes, go ahead.
Okay. Ms. Doby, I'm going to ask you a few more questions. Is that okay? Do you have a car?
I do not have one.
Do you have money in a bank account?
I do.
How much?
I'm not really aware of exactly how much, but I get monthly money from my disability,
And how much is that per month?
$1,300 a month.
Okay. Did you have, the last time you checked the balance of your account, do you remember how much was in it?
I have someone that's taking care of that for me so that they could give money to me. But I mean, coming up with the money would not be a problem monthly.
So, but hold on, do you say you have someone taking care of that? Is that the probate lawyer?
We do have a probate lawyer, but my cousin takes care of my account.
And who's your cousin?
Regina Flakey.
Okay. And did you have more than $2,500 in your account last you checked?
Yes.
Did you have more than 5,000?
No.
Okay. So somewhere between $2,500 and $5,000 in your account,
Yes, sir.
and you get $1,300 a month in disability?
Yes, sir.
Okay. And you do have a house to go to, and you do not have a car, correct?
Right.
Do you have a job?
No, sir.
Okay. Okay, that's all I have, Your Honor.
I was a stay-at-home mom.
Okay.
Ms. Heisel, any follow-up questions?
No, Your Honor.
Okay, go ahead and continue your argument, Mr. Linder.
Thank you, Your Honor. So based on what you've heard, and thanks for allowing me to recall her, she does have a little bit of money, not a lot. She has a place to live. She gets $1,300 a month in disability. And she doesn't have a car, any way to really go anywhere, but she can't afford a leg monitor. And I think through her probate lawyer and her father's estate, they might be able to come up with some friends. They may be able to come up with enough money to post 20 grand or so in a bond. We just don't know, but we know they can't post 50 grand or 75 grand to pay the bonds they have now. But I do believe there are conditions the court could put in place where she would not be a flight risk or danger. And as she mentioned, she has no criminal history, Your Honor.
All right, thank you, Mr. Linder. Ms. Heisel?
Your Honor, the state will concede that Ms. Doby has no criminal history prior to this incident. The state's problem is that this incident, the state's alleging that Ms. Doby is at minimum a party, if not an active participant in a capital murder where there is a child present, a child that she would theoretically have access to if she were released on bond. The state believes she is entitled by law to a PR bond on the one charge, which lowers her overall bond posting by a third. But Judge, given the serious nature of the allegations, the people involved in this, safety to both the community and to her children, we would ask that the bonds remain set where they are on the 2 indicted charges.
All right. Ms. Heisel. All right, the court's going to take the evidence under advisement, and I'll issue a ruling at the conclusion of the docket today.
Thank you, Your Honor.
You're welcome, and I'll send my ruling in writing to both parties via email.
Thank you, sir.
You're very welcome. All right, let's set Ms. Doby then. Court will grant one additional docket call. Do you have your calendar available, Mr. Linder?
I do, Your Honor.
Look at September 22nd or 27th for me and tell me if either one of those is.
They're not going to be good for me, but I might can have someone appear for me. I have on September 14th, I start a federal jury trial in Washington, D.C. I represent Stuart Rhodes, the founder of the Oath Keepers, the guy with the eye patch that Liz Cheney put all over the January 6th commission. We start that trial. Actually, hold on. The pre-trial is the 14th, 15th. The trial starts on the 26th. So now, which day did you say, Your Honor?
22nd.
22nd would be a better day because that Friday I'll probably leave for DC. So that no, I apologize. 22nd works.
Okay, then we'll set Ms. Doby then for a docket call on September 22nd, and that will be at 1:30.
Thank you very much, Your Honor.
You're welcome. Now, if the court grants the motion to reduce bond and Miss Doby gets out, then her hearing will be at 9 o'clock in the courthouse.
Okay,
Or in the courtroom. Okay,
thank you, Your Honor.
all right, you're welcome. All right, if there's nothing further, then we'll be adjourned in Ms. Doby's cases.
Thank you.
You're welcome. All right, so Mr. Ashmore, are you ready on Mr. Shackelford or Mr. Shelton?
Judge, Mr. Shackelford's in here.
Come on up, Mr. Shackelford. CR 22-117.
Judge, we thought we were going to plea today because we were under the impression we had a time served offer. It's actually on his reset sheet from last time. And the state has reviewed the file. Apparently there was some miscommunication there. It was unintentional. The time served was, I believe what the state will represent was actually for Mr. Henry, and email threads were, it was the same two cases on the same email thread. And anyhow, that's what we wrote down and announced, but the state is not making a 1244A time served offer to Mr. Shackelford. And at this point, we're without a plea we can accept. So I'm just going to ask the court to set us for jury trial. The current offer is 15 months state jail. And I can't remember what the fine is. I'll ask Mr. Woodwike to clarify that. And we'll just get on the jury trial docket, and I'll ask the court to please entertain future plea offers if we can get this straightened out at some point in the future.
And what kind of credit time does Mr. Shackelford have towards any sentence that he gets? Do you know?
He's got, go ahead.
Judge, he's been in since January, so 7 months and change, something of that variety.
Okay. And Mr. Woodwike, is that the state's best offer?
15 months is as good as we're gonna get, Judge.
Okay. All right, then the record will reflect that Mr. Shackelford is rejecting the state's offer. Court will set Mr. Shackelford for jury selection. We'll begin that on October 3rd. If there's an agreement reached prior to trial, then the court will entertain a plea agreement if it's in compliance with the court's policy well in advance of him being number one.
Thank you very much, Judge.
All right.
And just 1 second, Your Honor, are we ready on Mr. Shelton?
All right, this is State versus Donnell Shelton, CR 2247 and 48, set for docket call.
Judges, I'm going to ask the court for one. I'm going to make an announcement and not ready. We got 7 DVDs in the last 30 days, 7 sets of very comprehensive discoveries, some of which we'd already gotten, but the court may recall that there was a production that was related to an unrelated case. And anyhow, Mr. Woodwike and the state's office did a diligent job and got me all that information they had around the COVID in their office in that last 30 days. We've had 2 lawyers down with COVID in the last 30 days, and Mr. Shelton and I have been unable to connect except on some very critical excerpts. He hasn't been able to see all of that discovery. Oh. Hang on, that's the wrong. Anyhow, my request is one last docket call. Alternatively, just like the case at this point to be set on the jury trial docket.
And what part of discovery has Mr. Shelton not seen that you think is important for him to see?
He hasn't seen all of the officer videos related to the final incident, the final moments involving this alleged offense. So there's 3 dash cam videos and 3 body cam videos, and then 1 other body and dash set. We've seen that one. It's the up close and personal stuff. We've seen some critical excerpts of 2 of those. And again, just like that opportunity, there's been a few things that have been beyond my ability to address with Mr. Shelton, like him, to have an opportunity to see all that and see where we're at, if we could.
And do you think those portions of the videos are material for him to make a decision on whether or not he wants to accept a plea agreement or not?
Yes, Judge, because otherwise it's been fairly inflexible positions by both sides. So I think if we have a little bit of time to digest, even if we come back on a shorter turnaround, just simply to give us the opportunity to work through those, play them all, and then he can have all that information, he can make that decision.
Okay, I think we're having some audio problems, video problems. State, do you want to weigh in on that at all?
Judge, I do know that there were multiple agencies involved in this, and I believe Kaufman County in specific is the agency that we got video recently for Mr. Ashmore. I do believe that shows a slightly different view of the event than the Van Zandt County videos. Given Mr. Shelton's condition after the events, I'm sure that those greatly aid in his recollection of the events of that night. So we would be unopposed to one more setting to allow him to watch those videos from that different perspective.
And what's the current offer for Mr. Shelton?
40.
40?
40, yes, Judge.
And is that on the ag assault?
Yes, Judge.
And what about on the firearm by felon?
I think that would be taken into consideration if we accepted the 40 or if there was some movement on that higher offense that the state would accept. I think they would take the other one into consideration.
Is that right, State?
Yes, Your Honor. I believe whatever we end up on will be on the public servant charge, and the felon in possession would be 1245.
All right, so what I'm gonna do, Mr. Ashmore, is what you said in the alternative. I'm gonna go ahead and set Mr. Shelton for jury selection on October 3rd, and I will entertain a plea agreement after today, but well in advance of him being set for trial.
Thank you, Judge. Judge, I'm gonna head up to the courthouse.
Okay, thank you, sir. I appreciate it.
Thank you.
All right, Deputy McLeish, I believe that resolves all of our cases set on the jail docket.
Yes, Your Honor. Is there anything else we can do for you here at the jail before we log out?
No, ma'am, I don't believe so.
All right, thank you, sir.
Thank you for your help. All right, we'll stand in recess to allow Mr. Ashmore an opportunity to get back over here to the courthouse for Zoom. And I'm going to check in to see if Mr. Kritz, Mr. Atkins are available. So let me see if they're set up. We'll stand in recess for just a few minutes.
Okay, to unmute myself, all I do is just. Oh, okay.
I didn't unmute. Okay, y'all should be on this minute.
All righty. Ready to play. Yeah. Not a big fan of hurry up and wait, even though I'm a lawyer, because I don't charge by the hour. You know,
That's good though.
when I first started doing court appointments, things were a lot slower and had one judge that went on the last name of the law. I'm W. So I'm up here at 9 o'clock and at 3 o'clock.
Your mic is on.
Oh, oh, thank you. $6 well. 4:20. I don't mind charging the county.
Right.
Can you see on this one? Mr. White,
Yes,
are you ready?
yes, we are, Judge.
All right, this is cause number CR 22-1, CR 22-236, State versus Seth Edward Atkins, and Mr. Atkins was set for docket call and arraignment, and he was also set for status to hire an attorney. I called the case this morning, told Mr. Atkins to return at 3 p.m. with counsel. And Mr. White, have you been retained as counsel?
Yes, I have, Your Honor. I don't have a letter of representation in yet, but I will be getting one in tomorrow.
Okay, all right. The court will recognize you as an officer of the court and as counsel for Mr. Atkins. And have you had an opportunity to review the indictment in CR 22-236?
We have, Your Honor, we've got a copy of it, and our name is spelled correctly in the indictment, and we are now entering a plea of not guilty.
All right, court will enter Mr. Atkins' plea of not guilty into the record. We'll find that he's waived the formal requirements of arraignment. Court will set CR 22-1 and CR 22-236, both for pretrial. Are you available on September 22nd, Mr. White?
Probably should be on 22nd. I've got somewhere around 12 cases on the 20th.
20th, yeah, I'm full on the 20th. I think I'm over my max. I can do the 27th if you're good.
22nd will be fine, Judge.
22nd, 2-2.
Yes.
All right, court will set pretrial each case September 22nd. Mr. Atkins, once you sign and get your notice of reset, you're free to go.
Okay, thank you, Judge. I believe that's all I have today.
Yes, thank you, Mr. White.
Okay, thank you.
Thank you, Your Honor.
You're welcome.
Okay, well, you wanna get like some, I need to, figure out some way I can get you paid before I'm gonna stress out.